The Supreme Court today handed down a major victory for gun control advocates.
God, how cool is this?
This is an issue that every gun owner should be concerned about, and we in Congress should be concerned about it too.
In a 6-3 decision, the court struck down New York's law, which places restrictions on concealed handguns.
The first major federal gun safety legislation in decades is now moving forward,
nullifying a New York law that required applicants to show a special need for a concealed carry permit.
The highest court in America just did something nobody saw coming. In a single morning, they dismantled over a century of gun control laws that millions of Americans thought were permanent. This isn't about one state or one law. This is about every single firearm permit in the country potentially becoming worthless paper. 6 justices against 3 just changed everything. The Supreme Court delivered a ruling so sweeping that even the Department of Justice backed away from defending the old system. States that spent decades building permit requirements watched their entire frameworks crumble in real time. What happened next shocked everyone. Multiple states immediately began rewriting their laws. Police departments stopped enforcing permit checks, and an entire industry built on permission slips started collapsing. This story begins with a simple question that reached the Supreme Court. Can the government require you to get permission before exercising a constitutional right? The answer they gave will reshape America. For over 100 years, states controlled who could carry firearms through elaborate permit systems. Citizens had to prove they deserved their rights through applications, fees, background checks, and often subjective approval from local officials. Some states made it nearly impossible, requiring proof of special need or connections to the right people. Others charged hundreds of dollars in fees that renewed every few years. The message was clear: your rights begin when the government says so. That entire system just got destroyed. The Supreme Court ruled that constitutional rights don't require permission slips. They declared that the Second Amendment's protection starts with your existence as an American, not with a bureaucrat's approval.
As the nation deals with a recent wave of mass shootings, the Supreme Court expanded gun rights.
That law was enacted more than a century ago.
We want to see Congress pass laws that will help reduce crime without infringing on the rights of law-abiding citizens.
Justice's ruling this morning, it conflicts with the Second Amendment's right to bear arms.
State can't make everywhere a sensitive place. You can't go hiking in some places and not be able to defend yourself against somebody that you run into.
21 years and older who are allowed to own a handgun will no longer need a license to carry it.
The court drew a line that states can no longer cross. Fees, waiting periods, and subjective standards that turn rights into privileges are now constitutionally suspect. The most shocking part wasn't just the ruling itself, but who supported it. The Department of Justice, which historically fought against expanding gun rights, chose not to oppose this decision. Internal communications revealed that federal attorneys recognized the writing on the wall after previous rulings made permit systems legally unstable. They understood that defending these laws had become impossible under current constitutional standards. At least 15 states filed briefs supporting the shift away from permits. Federal officials acknowledged that licensing delays and approval systems conflicted with constitutional intent. The same department that once defended every gun control measure stepped aside, allowing this new era to begin without resistance. Before this ruling, constitutional carry existed in select states scattered across the country. Now it has legal backing nationwide. Every law-abiding American can claim constitutional foundation for carrying without permits. States that impose subjective standards or required citizens to prove good cause are exposed to immediate legal challenges. Judges across the country must now apply a single constitutional rule instead of 50 different interpretations.
The Second Amendment protects the right to carry a gun in public for self-defense.
There is a difference between states deciding how they want to regulate any number of things versus stripping people of their rights to self-defense.
The government may not regulate individuals' possessions of weapons for self-defense.
Saying setting a higher threshold in an emergency could mean life or death.
This is not a gun decision.
No.
It's not. This was not decided on Second Amendment grounds.
This is big.
We won't see changes overnight, but it's going to be quick.
The court made it clear states cannot require citizens to justify their need to exercise a right. This doesn't create something new, it restores something old. The right recognized by the founders, recently affirmed in other major cases, now has the full force of Supreme Court enforcement. The reaction from states with strict gun laws was immediate and panicked. California, New York, and Illinois watched their entire regulatory frameworks face collapse. These states built their policies on the assumption that permission and discretion were necessary for public safety. The court stripped away that justification completely. California's May-issue permit system became effectively void overnight. New York's complex carry restrictions, already weakened by recent precedents, cannot survive this new standard. Illinois faces a flood of lawsuits challenging every aspect of its licensing and training mandates. Gun rights organizations filed injunctions across multiple jurisdictions before the sun set on the day of the ruling. Sheriffs and state attorneys found themselves choosing between enforcing dead laws or accepting the new reality. Some departments announced they would stop permit enforcement immediately. Others waited for guidance that might never come. The confusion highlighted how quickly established systems can crumble when their legal foundation disappears. Behind every permit system was an entire industry generating billions in revenue. Application fees, renewal costs, training certifications, and administrative positions all depended on the permit structure. That economy is collapsing rapidly. States are canceling fee collections, training companies are losing government contracts, and databases tracking licensed carriers have lost their legal purpose. This financial disruption goes beyond government budgets. Private businesses built around mandatory training are pivoting or closing. Instructors who taught state-required courses are adapting to a market where training is voluntary, not mandated. The economic ripple effects will continue for years as the market adjusts to actual freedom rather than regulated permission. While some states reacted with resistance, others moved immediately to embrace the ruling. Governors and legislatures began emergency sessions to align state law with the Supreme Court's decision. They weren't just accepting the change, they were racing to make it permanent before any future court could reverse course.
For the Supreme Court, it's all about language, reasonable suspicion, objective reasonable belief, or probable cause.
House would keep gun owners' information private.
This will get appealed, and this might go back and forth a little bit, but for right now, this is where we're at.
The bill allows gun owners 21 years and older to carry a weapon in Tennessee without a permit.
Give us transparency in how you're going to handle them, and if there's a roadmap of what you're going to follow that's more clear, then it's going to be a fair process for everyone.
Florida's governor ordered immediate removal of concealed carry permit requirements. Texas and Montana passed emergency measures expanding carry zones to include previously restricted locations. Tennessee's Attorney General declared all local permit rules void under the new standard. South Carolina and Alabama started drafting constitutional amendments to cement these rights at the state level. This coordinated effort represents something unprecedented, states competing to expand freedom rather than restrict it. Legislators who spent careers managing gun control are now dismantling their own creations. The speed of change reveals how artificial the old restrictions truly were. Law enforcement found themselves in an impossible position. Officers trained to check permits and enforce carry restrictions suddenly faced a world where those rules evaporated. Some departments continued enforcement despite the ruling, creating conflicts with state attorneys general. Others immediately ceased permit checks but lacked clear guidance on what replaced the old system. Prosecutors began dropping cases related to permit violations to avoid civil lawsuits. Counties across Georgia, Idaho, and Arizona saw sheriffs publicly declare that permit checks were finished. Police unions requested emergency clarification to prevent officers from facing legal liability for enforcing dead laws. This transition period exposed the fundamental weakness of the permit system. It only worked when everyone agreed to pretend it was legitimate. Once the Supreme Court removed that pretense, the entire structure revealed itself as a house of cards.
This case could reshape how far states can restrict your right to carry and where.
This is a case that's been bounced around back and forth throughout the court system.
When things sound really good for gun owners in court, that doesn't mean it's over.
This is currently the rule until they decide to change their minds, which they inevitably probably will.
Everybody has a right if they're a responsible adult.
Gun control organizations responded with predictable alarm but surprising weakness. Press conferences and fundraising drives couldn't hide the reality. They had lost their most powerful tool. Decades of incremental restrictions through permit requirements vanished in a single ruling. Major gun control groups called the decision a constitutional disaster while pledging millions to help states resist. They began working with governors to draft new laws disguised as training requirements or safety measures. Blue states introduced bills declaring entire cities as sensitive zones, attempting to ban carry-through geography instead of permits. These efforts face an uphill battle against clear Supreme Court precedent. Any law burdening a constitutional right must survive historical scrutiny, and America's history doesn't support these restrictions. The anti-gun lobby finds itself fighting from behind for the first time in generations. This ruling represents more than a single decision. It completes a judicial transformation decades in the making, starting with recognizing individual gun rights, then applying them to states, then demanding historical justification for modern laws, and now eliminating permission requirements entirely. The court has established a clear principle: rights exist at birth, not after approval. Future firearm cases will be judged by text, history, and tradition, nothing else. Courts can no longer balance constitutional rights against political preferences or emotional arguments. The age of judicial compromise over gun ownership has ended. This generational moment doesn't just restore the Second Amendment, it reminds America how constitutional law should work. Rights deserve protection, not management. The government serves the people, not the other way around. Even with this landmark ruling, the real battle has just begun. How each state interprets and applies the decision will determine whether this freedom becomes permanent or faces new challenges. Lawsuits are already appearing in resistant states, while supportive states race to codify the changes. Gun control advocates prepare new proposals disguised as public safety measures. Federal agencies face scrutiny over whether their policies can survive under the new constitutional test. This moment separates temporary victory from lasting change. Courts and legislatures will continue testing boundaries, but the fundamental shift has occurred. The balance of power now favors the citizen over the bureaucracy. The Supreme Court drew the line, but the people must ensure it's never crossed again. This new phase demands vigilance, unity, and understanding from those who value constitutional rights. Nobody predicted this would happen so quickly. Not the media predicting gradual change, not the states assuming their systems were permanent, not even the activists who spent decades fighting the Second Amendment. But the Supreme Court has spoken decisively. Permits are fading into history while freedom reclaims its central place in American life. The next wave of decisions is coming soon. More challenges, more changes, and more opportunities to restore constitutional principles. Stay alert, stay informed, and above all, stay free. That's it for today, folks. See you in the next video.